AM 950, the progressive voice of Minnesota. Brett Johnson with you. Well, right now we're joined by Ross Stadheim with MJSB Employment Justice, their website, mjsbjustice.com. As today, as part of our continuing series with MJSB Employment Justice, we are going to be talking about whistleblower laws and whistleblower protections. What kind of protections do you have in the workplace if you do catch something that, well, your employer shouldn't be doing? Well, we're going to be chatting with Ross about that today with protections at both the state and the federal level. Ross, thanks so much for coming on the show today.
Absolutely, Brett. Thanks for having me.
Yeah, absolutely. So you and I had a chance to chat a little bit off air about whistleblower protection laws. And what I find interesting is that in Minnesota, we have some very robust laws that protect whistleblowers in our state, which is a little bit different from other areas of the country, which we can get into later. But let's at least start off at the Minnesota angle. What kind of protections do workers have in Minnesota if they do catch their employer doing something that maybe they shouldn't be doing?
Sure. Minnesota has one of, like you said, Brett, Minnesota has one of the most robust whistleblower laws in the country. The protections provided to Minnesota employees are um, codified in a law called the Minnesota Whistleblower Act. What the Minnesota Whistleblower Act does is it protects employees who make good faith reports of violations of law. And what are laws? Laws are, written down things, laws, rules, regulations, things of that nature. But in 2013, the Minnesota Whistleblower Act was amended and went even further than that. So it also now protects reports of common law breaches. And what's common law? We all remember common law from, maybe our civics courses. Common law are, they're laws that are passed down from case law. So things like, breaches of contract. So if, for example, if you went to your employer and you said, boy, you know what, I think that we are breaching our contract here. Or I think, Mr. Manager, that we are just not complying with this law here and we need to fix this. That's what we call in the whistleblower, representation community, a protected report. So if you make that report to your manager and then you are retaliated against for making that report, like let's say you make that report and you had good performance, so then all of a sudden, you're terminated for performance. That would be a good whistleblower case that you could call us for and that we would do a full case analysis for, Brett.
Gotcha. So let's talk about the retaliation aspect of these whistleblower laws, because I'm curious what defines as retaliation, because someone might be sitting out there thinking, well, I know our company is doing something that needs to be reported on, but I'm not necessarily getting fired from the job. But I'm sure there's still other ways that employers can retaliate against employees for blowing the whistle on something, correct?
Certainly. So the term adverse action is the term that we use in the law. And what does that mean? That just means that you're being retaliated against. To make your case, worth going forward with, you usually need to be impacted in your pocketbook, and that usually means a demotion or a termination. But there are other ways a employer can retaliate against you. They can't. I mean, one way would be like just not give you work. That could have an adverse impact on your pocketbook. Another way in retaliated against you would be, papering your file with, unjust discipline, giving you a bad performance review. Those can be indicative of adverse actions as well, Brett.
So I want to talk about some of the specific cases you've been working on in Minnesota, and one that you and I had a chance to chat a little bit about off air had to do with Minnesota Globe University, where you had a chance to represent a former employee of that business who ended up. Well, explain a little bit more what happened with this case.
Sure. So this case was one of the a very large case that we had, a number of different years ago. And it's a case that I handled at a previous employer, actually, not at MJSB Employment Justice. And actually, we've been, just to quickly mention this, a year ago today, we hung out our shingles. So this is our 1-year anniversary for MJSB Employment Justice. So, and I want to be clear to all the listeners out there, we have over probably 60 years of combined experience litigating these types of cases. But we came together a year ago and started this business. So we're really happy about that, and that we have been in business for 1 year, a very new milestone, but important nonetheless.
Oh, congratulations! That's awesome. So
Yeah,
1
appreciate
year.
that. Yep, 1 year. Anyway, this case that we had a number of different years ago was against Minnesota School of Business, which is also Globe University. And they had about, at the time, they had about 20 different campuses in Minnesota and Wisconsin. They had, campuses in Wausau, campuses in a couple campuses in Madison and in Eau Claire too. So they were pretty big. And they are what's called, a for-profit university that provided, a number of different programs like criminal justice. There was a paralegal program there. There was, a regular business program there, all sorts of different things. So our client was a former dean with essentially a perfect performance record. And she stood up during a meeting after she had this positive performance review, about 3 weeks after she received a positive annual performance review, and objected to management and the owners during a meeting. And she said, "Hey, you know what? Um, the numbers that we're advertising to students just aren't accurate. Um, we're advertising these perfect job placement rates, and that's just not true." Because, for example, she was recognizing that, like in a student with a business degree that was working like at Holiday gas station before they went to Globe University would then take the course, continue working at Holiday gas station, and then after they graduated would still have that Holiday gas station job with a business degree. And they were wrongly counting that person as placed within the job community. Obviously, they're not. They had that job before and it's at a gas station. That cannot be counted as placed. So she recognized that, reported that, and said that, hey, that's a violation of law. That's false advertising under Minnesota statute. And we're trying to, do that, and that's just wrong. After that, she was terminated 3 weeks later for, lo and behold, bad performance reasons. After she did that, and then so she came to us, myself in particular, and then 2 years later, we had, a trial out in Stillwater and won about $1 million in a verdict. And it was interesting because this was one of the first whistleblower cases against for-profit universities in the country that we were successful at. And after that, things got worse for Globe University. They started snowballing because we got a bunch of, press with regard to, that verdict. And the Minnesota Attorney General's office ended up suing Globe University for these false and deceptive practices. And they won their trial in about 2017, I think. And after that, things got even worse for Globe. They lost all of their federal funding for students and their state funding for students, and they had to shut down their 20 campuses.
So at best, this was a company that was operating unethically at best, if not illegal, as we obviously saw from that lawsuit. And I'm taking it this might not have been possible if it were not for Minnesota's whistleblower protection laws, correct?
It would not have been possible at all for if it was not for Minnesota's whistleblower protection laws, and also, the courageous client standing up and saying, "Hey, you know what? This just isn't right."
So, how do our laws compare to other states? I know, as you brought up, Minnesota has very strong whistleblower laws compared to other states, but I'm just curious what the situation is around the country.
Sure. I mean, there's a patchwork of different laws. Some states have, good whistleblower laws, and some states, excuse me, do not. Our neighboring state to Wisconsin, I wish they did have a good whistleblower law, but they really don't have a good whistleblower law at the state level. I hope that there's some grassroots efforts over to our east to make to pass some legislation protecting those employees who stand up to their employer and say, "Hey, you know what? This just isn't right. We need to fix this," because the whistleblower, they have their heart in the right place. They want to do things right, and they want to do things by the book. And those employees deserve protections.
I mean, if you're talking about what happened at Minnesota Globe University, they very easily could still be in business and deceiving prospective students. And because, as you said, just because of that one lawsuit that you were involved in, it snowballed completely and uncovered a lot of, well, fraudulent things that were happening out there. And that's thanks to the fact that, well, as you said, there was a courageous client that was willing to challenge what was happening. And Minnesota thankfully had strong laws. And if not for those, that college could still be around and still potentially, for lack of a better way of putting it, scamming students into enrolling in their university and not really getting placed for the job, even though they're getting promised that.
Exactly. And it was a little bit of a scam because, I mean, these students were paying a lot of money for, essentially a degree that wasn't advertised as, what it was purported to be.
So, if someone's an employee and let's say they do uncover some information that they think is worth blowing the whistle on, that the company needs to make some changes, what should someone do if they feel like they're being retaliated against? At what step in the process should they reach out to a lawyer? Is this something they should do right away or should they wait? Or I'm curious about that aspect.
Honestly, the moment that they recognize something wrong in the workplace, they should call us. Even before making what I referred to earlier as a protective report. Um, call us because we can guide you through that process. A lot of times, after an employee is terminated is when they'll call us, but there's nothing that says you can't call a lawyer when you're still employed there, and there's nothing that says you can't call a lawyer for advice when you're just contemplating, what you should do next after you recognize that's, there's something wrong in the workplace and you're just contemplating blowing the whistle on your employer.
So, what does that process look like if someone reaches out to you? Walk us through how that works.
Sure. All you do is email us or call us. We have, all that stuff on the website. And you'll get connected to one of our 4 partners at the law firm, and we'll provide you with a, free consultation, no questions asked.
So if someone does reach out to you and they're nervous about, well, I don't know if I want to get a lawyer involved in this case. I don't want to go through the hassle. Walk us through what you guys can do to help people feel at ease during that process of trying to well get justice for themselves.
Sure. Well, first off, I want to be clear. Like, even if you're a prospective client calling us, that's still protected by the attorney-client privilege. I can't tell anybody. I can't go and be like, oh, you call me and I know, somebody who works at Medtronics or I know somebody that works at St. Jude Medical. And I'm gonna, inform them that, hey, something's up. I would lose my license if I did
Mhm.
something like that. So the attorney-client privilege protects all of the conversations with regard to prospective clients. Then after that, we'll after you call us, we'll for the free consultation, we'll just give you free advice, and it's the prospective client is willing to take that advice. It's up to them. If it's a situation where the employee ends up getting retaliated against and terminated, or demoted, then that's something that we might sign you up for.
Speaking with Ross Stadheim of MJSB Employment Justice about whistleblower protection laws. And next, I want to talk about some of the types of clients that you represent, because obviously, as we were talking about, that was a very high profile case where you represented a client that was suing Minnesota Globe University. But as I'm sure you can attest to, you represent clients that come from all sorts of different industries, correct?
Absolutely. Myself personally, I've represented everybody from, a person who works at McDonald's all the way up to somebody who was a C-suite executive at a very large Minnesota company, in all walks of life in between, blue collar, white collar, um, any type of collar.
So, if someone does experience retaliation in the workplace, what's the one piece of advice you would give to someone to make sure that they need to do to make sure that they are getting justice for themselves?
Uh, you know what? The one thing that I would really advise that somebody does is, you know, take good notes. Keep if there's evidence that you have in your email inbox, print off those emails and put them in a file. Gather evidence, because you just never know, what could be coming down the pipeline. You should protect yourself, and of course, you should also call us for legal advice and guidance throughout that process as well. Everybody always thinks that it's not going to happen to me,
Mhm.
that I'm intricate to my employer. I'm important. And that very well may be, but we're all just numbers sometimes, Brett. And we're all expendable. It's a harsh reality that I've realized, during the course of my career.
And going back to the point that you were talking about with note taking, let's say you are in that type of situation where maybe you think you are trying to change something at a business, but you could be getting retaliated against or having actions taken against you. That documentation can help because you don't want to get in that situation where it's just hearsay, where it's a he said,
Right.
she said situation, correct?
That's correct. Correct. And if and by the way, in Minnesota, you can also record conversations. Okay. So if you and I were in a room and you were my manager, Brett, and I'm thinking that maybe I'm going to get terminated, I could turn on my iPhone and record the conversation without informing you. But let me be clear, both parties have to be in Minnesota in order for somebody to, secretly record a conversation. That is allowed. But I do want to be clear, if your employer has, like a rule, like an internal rule in its handbook against recording conversations, that would be a legitimate reason to terminate somebody. So you have to be very careful about your decision to record conversations. And if the other person on the other end of the line is like in, a different state, you're going to have to do a little bit of legal research to figure out if, you can record that conversation. But if both parties are in Minnesota, you could certainly record the conversation if you wish.
Well, that transitions to the next point I wanted to bring up. We've been talking about state protections, at least with whistleblower laws, but I do want to switch to the federal level now because things are a little bit different when it comes to, well, at least whistleblowing at the federal level. Can you explain a little bit more how that works?
Sure. So federally, there really is no overarching whistleblower law like we have in Minnesota. There's no really overarching federal law, like the Americans with Disabilities Act that protects all disabled people. What exists is kind of a patchwork of laws that protects certain situations in certain industries. For instance, if you're a federal employee, they have their own whistleblower law. If you work for the railroad, they have their own whistleblower law. If you work for the airline industry, they have their own whistleblower law. But there is an interesting law that I think is worth discussing called the False Claims Act. This law dates all the way back to the 1860s and is meant to protect the government and the taxpayers from fraud. So essentially what happens in these types of cases, Brett, is the whistleblower recognizes a type of fraud against the government that implicates taxpayer dollars. For example, if you worked for a big defense contractor that made airplanes and the airplane manufacturer was representing to the Department of Defense that their airplane could fly at, let's say, 90,000 feet. In reality, the maximum altitude that plane could go to was like 70,000 feet. That would be a false claim and a fraud against the taxpayer and a fraud against the government. So if that employee worked at a company like that and recognized the false claim, that person could blow the whistle by telling somebody like myself, a lawyer, about the fraud. And after that, it's a little bit interesting and different from, a regular type of, case. After that, because it implicates taxpayer dollars. But after that, the lawyer would, if it was an interesting, good case that the whistleblower had, evidence of, a lot of taxpayer fraud, the the lawyer would go try to pitch the case to, the government. And if there's a significant amount of taxpayer dollars in the balance and the whistleblower had, a lot of documentation detailing the taxpayer fraud, then the government would decide, hey, you know what? Let's prosecute this case. Let's intervene. A bad part about these types of cases is you'd have to have a mountain of evidence because the government is very picky and choosy about the cases that it wants to take. The cases also take a super, super long time to do. And if, let's just say, the government took on a case on behalf of a whistleblower I represented, then after that, a lot of stuff is done in secret for many, many years. And then just at the end, you're informed if they settle the case and for how much. And if they do settle the case, the whistleblower and, by implication, the lawyer are paid a hefty bounty, so to speak.
Interesting. So, as you were bringing up that's a system I had no idea existed. That essentially you can be a bounty hunter, essentially trying to pitch these types of cases to the government. But the point I think you were bringing up is that it's very hard to get the government to actually take these cases, and if they do, they take a long time to work their way through the court system. So, I think, in other words, that kind of means that really it would probably be helpful to have some better protections at the federal level because right now it sounds like it's very difficult to actually even get those cases through.
Absolutely, absolutely it is. Those types of cases, those we call them FCA cases or false claims act cases. They really have to be special cases. I mean, these are the cases when the government settles, they make huge headlines like government recovers $600 million based on Medicare fraud. Government recovers $1 billion based, from name the company based on false claims represented for a tank manufacturer or something like that. They're really huge cases that make big headlines when they settle.
So really, it's these state protections that are the bigger laws when it comes to whistleblower laws, and I'm guessing that can kind of make things complicated if you're dealing with a company that probably has offices in multiple states. I imagine that can definitely complicate things when it comes to whistleblowing. Correct?
It certainly does. But for the most part, to make it simple, if you live and work in a certain state, that's the state that applies, no matter where the company's headquarters are in.
Gotcha, because that's where I was thinking right now. If someone, let's say, runs into a situation where they're obviously working for a Minnesota or a Wisconsin company, if you're someone who's working out in Wisconsin, and let's say, yeah, someone does have their corporate office in Texas or California or New York, even though those corporate offices are located outside of where you live, you still get the protections of the laws of which state you live in, correct?
Typically speaking, yes, Brett, that is correct.
Okay, good to know because I think, yeah, people might be nervous about that if they're in this type of situation. Well, I don't know if I want to go under Texas's whistleblower protection laws because they not might not be as strong. I'm not sure if that's the
Right,
case.
right. It's usually where you live and work. Yep,
Usually where you live and work.
yep.
Well, we have
Where your domicile is what is the legal term that we use, but it's just where your house is and where you spend most of your time.
We have been speaking with Ross Stadheim. He is with MJSB Employment Justice, as today we have been having a conversation about whistleblower protection laws. You can find more about MJSB Justice at mjsbjustice.com. Ross, really appreciate you coming on the show today. I've learned a lot about whistleblower protection laws that I did not know existed, so I appreciate you coming on and taking the time.
Thanks a lot, Brett. It was a pleasure.
Excellent. Got it recorded. Let me just stop the recording on my end. And yeah, I can send that over to you.
Okay.